So good evening. We've been discussing this during this session, in fact, to what extent economics could be used in the application, in the development of competition law and policy. And as a judge and as a lawyer, I have been trying to draw the attention of our friends, economists, on some of the things that are important for us. Particularly, we have the same notion of truth, being an opinion which is shared by some people, a panel for judges or a community of scientists for economists. But we don't necessarily have the same approach to truth. An economist would try, as soon as he has a theory, to invalidate it in order to improve his theory, whereas a lawyer would systematically try to find coherence with what has already been decided in the past. And that brings along all sorts of necessities, like it's probably one of the reasons why whenever there is a change in the jurisprudence, it is minimized, like in Intel, where we say that it has been clarified. Also a reason why we seek to conciliate, to make compromises between different opinions in order to not to abruptly change the jurisprudence. We tried systematically to relate to precedents, that's the stare decisis. I also said to our economist friends that they should remember who we are, that is only judges applying the law. And so we can't go against the law. And judges applying, particularly when it comes to 101 and 102, provisions which have a quasi-criminal signification or impact, meaning in terms of review by a judge, the review must be full on the one hand, and in terms of burden of proof, it has to be beyond reasonable doubt. Also, I reminded our friends, economists, that we have to take into account all sorts of objectives which are in the legal system. Efficiency is certainly one of them. If you take a look at Google Shopping, you also see that fairness is not far away, and it's actually already included in 101 and 102. I also said, and that's something which everybody has to get in mind, that we have to be pragmatic. Competition law is now being applied not only at European level, but in the member states. And in the member states, courts and agency must have standards to apply that are relatively easy and easy to manipulate and to apply, in fact, and to use in the cases that are before them.